Alright, so a couple days ago, I made a video about how NewJeans lost appeal. The Seoul High Court has rejected all appeals made by NewJeans. I was able to get my hands on the actual court ruling, and after reading through it, I found it very significant, interesting, and fascinating, especially when it comes to the wording and the expressions and the phrases that the court used. So I thought it was worth covering it in a video, so here we are. This might take a while because it's a 16-page long document, so bring your cup of tea or coffee or something, make yourself comfortable. And then I'm not gonna, I have done a full translation and we'll post it on my Patreon page, but I'm not gonna do a word for word translation because the wording is a bit complicated, so I will do a translation in a more plain language, okay? Alright, so here we are. On the first page, or first of all, this case is about a decision from the Seoul High Court, okay, and it's an appeal against an early temporary order. And by appeal, we mean a request to a higher court to review a lower court's decision. And on the first page, it describes who's who. And here's a legend of acronyms and abbreviations used in the court documents, like ADOR, NewJeans, HYBE, Min Heejin, and 5 members of NewJeans, Source Music, Min Heejin, Belief Lab, Islet, Dispatch, NJZ, BU, AV, a PR staff member from HYBE, and AX, the project Team N, when NewJeans members were still trainees at Source Music, and so on. Okay? Alright, so on the first page, it describes who's who. ADOR is the company suing, right? They're the ones who started this legal action. Their CEO is named here, 대표이사 B, probably Kim Ju-young, and they have a team of many lawyers representing them from Kim and-jang. Now, for NewJeans, the 5 members are mentioned here, and they're appealing their earlier decision. Now, an important note, Heejin was a minor when the first lawsuit happened, but she's an adult now. That's what they say in the footnote. There are like 11 footnotes in total for this document. And footnote number 2 says this. Heejin is still a minor. Her mother, BC, is legally representing her because her parents couldn't agree on how to handle the lawsuit, and a family court decided that only her mother could make legal decisions for this case. And we have talked about this one on my channel. Very unfortunate how the whole Min Heejin issue led to a family feud. Alright, and then NewJeans also have a large team of lawyers from 2 different law firms. One from Sejong, and then one from a law firm called Useung. There are 3 lawyers from Useung. Alright, so the first decision in this case was made by the Seoul Central District Court on April 16, 2025. 서울중앙지방법원. Now, what the higher court ordered? The Seoul High Court has rejected all of NewJeans' appeals. This means that the earlier temporary order against them still stands, and NewJeans will also have to pay for the legal cost of this appeal. All right. And then here's what each side asked for. So that's with introduction, we have covered this. First instance decision, we have also covered this. Prayers for relief and grounds for appeal. So this talks about what each side asked for. ADOR request is that ADOR wanted the court to uphold the original temporary order. This order was issued on March 21st, 2025, stated that ADOR is still NewJeans management's company and that NewJeans cannot sign advertising deals or similar contracts without ADOR's permissions. On the other hand, NewJeans wanted the court to cancel the first decision and the temporary order altogether. They wanted ADOR's request to be completely dismissed. And then, here's a reasoning why the court made this decision. The High Court found that NewJeans' arguments in this appeal weren't very different from what they said in the first court case. 항고인은 제1심에서의 주장과 크게 다르지 않다. So after looking at all the evidence and the arguments, the High Court felt that the first decision to support the temporary order was fair and correct. And they found no major legal mistakes that would change the outcome. So the High Court's reasons for its decision are largely the same as the first court, with just a minor date correction. Like for example, November 29th, 2024 was changed to November 19, 2024. And they also added more detailed judgments on some of NewJeans' key points, which are explained next and which are the fascinating parts in this document. Okay? And then, it seems like the fact that the court said they found that NewJeans' arguments in this appeal weren't very different from what they said in the first court case tells us that there was no groundbreaking evidence that NewJeans members or their lawyers submitted, including that mysterious USB that they allegedly submitted to the court. All right, next, 이 법원의 추가 판단, the court's additional explanation, or the reasoning, additional judgment of this court. So the court next summarizes what the NewJeans members argued. Okay, so their main arguments was that their trust in ADOR was completely broken down because ADOR and its parent company HYBE treated NewJeans unfairly compared to other groups under HYBE. ADOR didn't fix these issues despite NewJeans' complaints, and they felt that Min Heejin, their main producer, was key to their contract, but HYBE unfairly audited and then fired Min Heejin from her CEO role. And they claimed that this destroyed the trust between them and ADOR. NewJeans also said that forcing them to stay under contract and work against their will would unfairly limit their personal freedoms as artists. They believed their contract should be considered ended because of this broken trust. They also argued that if the court allowed them to work independently, ADOR would only lose money, like profits, which could be fixed. But if the court kept the temporary order in place, NewJeans would suffer irreparable damage from being unable to work for a long time, harming their careers and artistic freedom. They felt there was no real need for a temporary order to stop them from working independently before the main trial about whether the contract still valid was finished before the main trial was finished. And I put question marks here and there because these are the main points, main arguments made by NewJeans, summarized by the court. But even then, I was like, I just don't understand what they were saying here, their logic and their reasoning. Anyways, next, the court's take on broken trust and other points. Judgment on breakdown of trust and relationship, etc. Okay. Now, first, was Min Heejin or HYBE the core of the contract? Okay. So that's the question that the court asked. The court explained that an exclusive management contract is about an agency providing services while the artist agrees to only work through that agency. So first, they defined what exclusive management contract means. To understand this contract, the court looked closely at how HYBE and Min Heejin were involved. So this was interesting, this sentence. 특히 채무자들이 문제 삼고 있는 AB와 AD의 지위 및 역할에 대하여 구체적으로 살펴볼 필요가 있다. Here's a literal translation. Okay, here we go. Therefore, to properly understand the legal nature of this exclusive contract, which governs the rights and obligations between ADOR and NewJeans, it is necessary to concretely examine the underlying circumstances, especially the status and the role of HYBE and Min Heejin, which NewJeans are raising as issues. So, NewJeans members were trainees at Source Music before ADOR existed, the court says. The court found no clear proof that Min Heejin was directly involved in selecting most NewJeans members as trainees. And this is pretty significant, I thought. According to the records, the following series of premises or underlying circumstances related to this exclusive contract can be identified. And then the court lists each member and when she signed a contract with Source Music. Originally, NewJeans were trainees under the name AX, that is N-Team or Team N, project name Team N, belonging to Source Music. Source Music entered into trainee contracts with NewJeans, starting with Minji on November 23, 2018, followed by Hani on November 23, 2019, Herin on February 3, 2020, Danielle on July 16, 2020, and Hain on January 19, 2021. In particular, Minji was already selected before Min Heejin joined HYBE, and there's no objective evidence that Min Heejin directly participated in the process of selecting the remaining NewJeans members as N-Team members or Team N members of Source Music. Now, this is something that we have already heard about by reading the exclusive article released by Dispatch back in July of last year, which I have also covered. And that particular part, when the members signed with Source Music, was written like around here. Oh, there we go. It's very significant that the court, right from the get-go, has stated that, look, I know what Min Heejin has been saying, that she's the mother of NewJeans, like NewJeans' mom, but look, she wasn't involved with the selection of NewJeans members in the very beginning. It was Source Music. It was Ho Sung-jin. So I would say, is Ho Sung-jin who's the metaphorical parent of NewJeans members, if you are thinking about it that way. And then, where is it? Yeah. So ADOR was, and then the court says, ADOR was created by spinning off a part of Source Music specifically for NewJeans, and Min Heejin became its CEO. HYBE then bought ADOR's shares from Source Music and invested heavily in ADOR for NewJeans. HYBE and ADOR, along with Min Heejin, signed other agreements about Min Heejin's stock options and HYBE's support for ADOR. HYBE continued to invest a lot of money in ADOR. Also, the actual 7-year exclusive contract between ADOR and NewJeans was signed in April 2022. Importantly, this contract did not include a keyman clause, which would have explicitly stated that the artist's relationship depended on Min Heejin's side. And this is pretty important. 이 사건 전속 계약에는 민 헤이진의 역할과 관련하여 연예인이 매니지먼트 회사의 특정 매니저와 업무 관계를 맺겠다는 점을 명시한 이른바 keyman 항목이 포함되어 있지 않다. Keyman clause. Are we here? Keyman clause. Oh, here we go. This exclusive contract does not include a so-called keyman clause that explicitly states that the entertainer will have a business relationship with a specific manager of the management company in relation to Min Heejin's role. Okay. Later, Min Heejin became unhappy with her agreement with HYBE, the court says, and tried to find ways to break free from HYBE's control and gain independent control of ADOR, even trying to get HYBE to sell its shares. Another significant part that I noted, the fact that the court actually said this at the same time. This is a literal translation of the court document. So, however, from around December 2023, Min Heejin became dissatisfied with the content of the shareholders' agreement and demanded its modification. At the same time, Min Heejin sought ways to break away from HYBE's control with NewJeans or to pressure HYBE into selling ADOR's issued shares held by HYBE, thereby weakening HYBE's control over ADOR and allowing Min Heejin to independently control ADOR. So the court is acknowledging the fact that Min Heejin indeed tried to do all these things, even though her supporters continue to say that, oh, how could you be able to break free or take NewJeans out of ADOR if HYBE is a major shareholder with 80% share? But, the court acknowledges that, okay, whatever the possibilities were, Min Heejin actually had these secretive plans behind the back. All right, next, considering all this, the court found that Min Heejin was not a key premise. This is one of the most significant portions of this document. The court found that Min Heejin was not a key premise of the exclusive contract. Instead, the court believed that HYBE was the core to foundation, or HYBE was the core foundation of the contract, as they recognized the trainees created ADOR for NewJeans, invested huge amounts of money, and provided resources. The court saw, check this out, the court saw Min Heejin as someone who was destroying the foundation of the whole setup. You see how I drew this little star here? And let me read a literal translation as well, because this is pretty important. Here we go. Rather, considering that HYBE properly recognized NewJeans, who are trainees at Source Music, established ADOR as a company solely for NewJeans through the spin-off of Source Music, and it was also HYBE that took measures to support NewJeans by entering into a separate contract with Min Heejin in the process. Especially that HYBE unilaterally invested such a large sum for NewJeans and also provided HYBE's tangible and intangible resources to NewJeans through the BU contract, which was possible because HYBE was a large agency. It is reasonable to view HYBE as the core premise or basis of this exclusive contract, not Min Heejin, having overseen the entire process before and after this exclusive contract and integrated ADOR, Min Heejin, and NewJeans to achieve great results. Now check this out. Min Heejin is merely judged to be in a position that is currently destroying the foundation of this integrated structure. Bam! The wording of the court, the judge. Ain't that significant? Okay, so to summarize, here's a summary. Right? The court analyzed the nature of exclusive management contracts and the roles of HYBE and Min Heejin's and NewJeans formation. It found no objective evidence that Min Heejin directly participated in selecting NewJeans members. The court highlighted that HYBE established ADOR solely for NewJeans, acquired shares from Source Music, and made substantial investments. And then, crucially, the exclusive contract did not contain a keyman clause linking the members' relationship to Min Heejin's role, and thus, the court concluded that HYBE, as a major investor and overseer, was a core premise or basis of the exclusive contract, while MHA was seen as destroying the foundation of this integrated structure by seeking to break away from HYBE's control. Therefore, the argument that Min Heejin was a key premise was rejected. Boom. Alright, moving on. 이 사건 전속 계약의 특수성에 대하여, regarding the specificity of this exclusive contract, meaning what makes this contract special. The contract has strict rules about ending it. It says the contract can only be ended if one party seriously breaks a main part of the agreement. It also clearly states that both sides understood ADOR invested a lot of time and money in NewJeans. It warned that if NewJeans broke the contract early, ADOR would suffer significant irreparable damage and could lose all its investments. The contract even included a large penalty that NewJeans would have to pay if they ended it early. The court emphasized that idol groups require huge investment from their agencies, and these investments only pay off thereafter debut. If NewJeans left early, ADOR would lose everything, and NewJeans would unfairly get all the future profits. The court also stressed that the contract's strong wording about its binding nature, including the reasons why it was so binding, that is ADOR's investment, should be respected. Okay, this means that NewJeans couldn't just end the contract based on their personal feelings, unless ADOR had seriously violated a core part of the contract or the trust was truly, completely broken. 채무자는 자신의 주관적 사정만을 들어 계약을 일방적으로 파기하거나 계약 관계에서 임의로 이탈할 수 없다고 보아야 한다. Now, NewJeans claimed that they didn't fully understand this part of the contract, but the court rejected this, saying they negotiated each clause. So you see how I circled, draw a red circle around this word 그러나. 그러나 means but or however. So this is how the court first states what the NewJeans members argued previously, and then state their own decision. However, something like that. Okay, saying that they negotiated each clause. NewJeans also tried to use a past Supreme Court decision from 2019 that allowed a contract to be ended if trust was simply damaged. But, again, 그러나, however, the court said that that case was different because it didn't involve a contract with such strong binding clauses and a clear record of massive investment, as in ADOR's case. They also stated that even under that Supreme Court ruling, a contract can't be ended just because of one side's subjective feelings. 주관적인 사정만을, if trust isn't genuinely broken. That's what they said right here, that I underlined with red marker. 위 주장은 이유 없다. Also, NewJeans argued that this strict contract clause was unfair and against the law. But the court said the contract was negotiated, not a standard like take it or leave it form. So it wasn't subject to the Terms and Conditions Act. Even if it were, the clause wasn't unfair because it didn't completely prevent NewJeans from ending the contract if ADOR seriously failed its duties. So, pretty significant. Right, so here we go. So, quick summary. So the court examined Article 15 of the exclusive contract, which outlined conditions for termination and penalties for unilateral breach. It emphasized the contract explicitly acknowledged ADOR's long time and considerable cost for NewJeans' debut, and stated that unilateral breach would cause significant, irreparable damage to ADOR. And this unique clause was seen as an agreement to strengthen the contract's binding force. And then the court rejected NewJeans' argument that they were unaware of Article 15's implications, noting they went through a negotiating process for each clause. The court also dismissed the argument that the contract was unfairly disadvantageous or violated the Terms and Conditions Act, as it was not considered a standard terms and conditions contract, but rather a negotiated one. And then it did not completely exclude the members' right to terminate for ADOR's material breach. Okay? So, there you go. Next part, I thought this was quite fascinating when the court talks about, where is it? 민희진 관련 파탄 사유에 대하여 regarding grounds for a breakdown related to 민희진. In other words, was Min-Heejin's situation a reason to break trust? So, NewJeans argued that trust broke down because Min-Heejin could no longer produce them, the court said. Now, the court responded like this. First, the contract didn't require Min-Heejin to be NewJeans' exclusive producer or remain ADOR's CEO. 이 사건 전속 계약 어디에도 it could be found nowhere in this contract. 민희진이 채권자의 대표이사로 재직해야 한다거나 민희진이 채무자들의 프로듀싱을 총괄해야 한다는 내용이 나타나 있지 않다. Could be found nowhere. And here AD refers to Min-Heejin. And the court pointed out that Min-Heejin's dismissal was due to her own actions, trying to break away from HYBE's control. Another little star that I drew. 자신이 채권자를 독립적으로 지배할 수 있는 방법을 모색함으로써 통합구조의 기초를 파괴하였다는 점은 앞서 본 바와 같으므로 위와 같은 사정은 민희진이 스스로 야기한 것일 뿐이다. We gotta read the original language for this part. Where are we? Which page? Page number 8. Okay. Trust between has broken down merely because you insist on this part. If it were known that has neglected. Alright, give me a few seconds. 파탄 사유에 대하여. 파탄 사유에 대하여. Okay, here it is. Trainees and nowhere. Okay, nowhere in this exclusive contract is it stated that Min Heejin must remain as ADOR's CEO or that Min Heejin must oversee NewJeans producing. And then here. However, as previously stated, from around December 2023, Min Heejin became dissatisfied with the content of the shareholders' agreement with HYBE and demanded its modification. At the same time, Min Heejin sought ways to break away from HYBE's control with NewJeans, or to pressure HYBE into selling ADOR's issued shares held by HYBE, thereby weakening HYBE's control over ADOR and allowing Min Heejin to independently control ADOR, thus destroying the foundation of the integrated structure. Therefore, these circumstances were brought about by Min Heejin's own actions. Boom. Quite cathartic, I would say. And then NewJeans also argued, the court explained, there was a change of circumstances because Min Heejin was no longer producing them. The court rejected this, saying that change of circumstances refers to major, unenforceable objective changes, not one party's personal preferences. See how the court keeps saying, like, you cannot say these things or do these things just because of your personal feelings or personal preferences, right? And they found Min Heejin's actions were self-inflicted and not an unforeseeable event that would make the contract unfair to maintain. 하이브와 민희진 사이의 갈등으로 인한 사정일 뿐이므로 이로써 이 사건 전속 계약이 기초한 채권자와 채무자들 사이의 신뢰관계가 파탄된다고 볼 수는 없다. These are merely circumstances arising from the conflict between HYBE and Min Heejin concerning ADOR's management rights, etc. And therefore, this cannot be considered to have broken the relationship of trust between ADOR and NewJeans on which this exclusive contract is based. Okay? So I think that sums up nicely. All right. So quick summary. The court addressed NewJeans' claim that the trust was broken due to Min Heejin's dismissal and her inability to produce them. So the court stated that Min Heejin's participation in member selection was unproven, and the exclusive contract did not require her to remain CEO or solely handle their producing. It also noted that MHA's dismissal resulted from her own actions, as she sought to break away from HYBE's control and gain independent control of ADOR. The court also clarified that HYBE's actions towards Min Heejin cannot be equated with ADOR's actions towards NewJeans, viewing it as a conflict over ADOR's management rights, not a breach of trust between ADOR and NewJeans. And even after Min Heejin's dismissal, ADOR actively sought to retain her as producer, and when rejected, looked for new producers, demonstrating efforts to fulfill its duties. The court found that NewJeans insisting on Min Heejin alone did not constitute a breakdown of trust. And the argument of a change of circumstances due to Min Heejin's role was also rejected, as her role was not a core premise and her actions were self-inflicted, not an unforeseeable objective change. All right, next part. Regarding other grounds for breakdown. 나머지 파탄 사유에 대하여. In other words, were there other reasons for broken trust? The court says NewJeans brought up several other points, and here we're going to see them talking about Belief Lab and Eyelid. Eyelid members, they said, not greeting Honey and a manager saying ignore her. The court found it hard to prove this happened, as NewJeans claimed. It also noted that ADOR took steps to handle the situation, like contacting Belief Lab, Eyelid's agency, reassuring NewJeans, and even issuing a public statement. They chose not to escalate with lawsuits due to advice that it might not be effective and could hurt NewJeans' reputation. The court said these isolated incidents were not enough to break the fundamental trust between ADOR and NewJeans. And it even noted CCTV showed initial greetings, right? Should I read that part? Actually, yeah. Where is it? Is one of the footnotes. Regarding other grounds of breakdown, failed to action, rather than current materials, members intentionally ignored. Footnote, yeah, this part. Rather, based on the current materials, it is difficult to substantiate that ILIT members intentionally ignored Honey or that ILIT manager made such statements. Regarding the ignore incidents, ADOR requested a meeting with ILIT manager from Belief Lab, ILIT's agency, around September 24, 2024, and around September 25th and October 8th, 2024, explained to actually, let's skip that. Footnotes. Even based on NewJeans' own claims, the ILIT members greeted Honey when they first encountered her. And this fact can also be confirmed by the CCTV footage submitted as evidence in this case. The ILIT members also appear to have greeted Danielle, who was walking from the opposite hallway. Even according to NewJeans' claims, the ILIT members' failure to greet Honey was a one-time occurrence, and ILIT members did not repeatedly ignore or transparent treat NewJeans, their senior idol group. And that CCTV footage we have also seen before, right? The so-called 90-degree bowing. Okay, next, the plagiarism allegations. ILIT copying NewJeans' concept and a trainee video leak. The court found these issues were not directly about trust between ADOR and NewJeans. ADOR, under Min Heejin at the time, protested the concept copying to HYBE. ADOR also contacted Dispatch repeatedly about the leaked video and hired a law firm to get it removed. The court concluded that ADOR took appropriate action for these situations. How about ADOR making negative comments about NewJeans in court? So NewJeans claimed this broke trust, but the court said ADOR was just explaining why NewJeans' reasons for ending the contract weren't valid and didn't see it as a trust-breaking act. And the court found that other reasons presented by NewJeans were also not sufficient to prove a broken trust relationship. So here's a summary. NewJeans also cited other incidents grounds for broken trust. ILIT members alleged disrespect towards Honey and a manager comment to ignore her. The court found it difficult to substantiate these claims and noted that ADOR took reasonable steps like requesting meetings, internal communication, issuing official statements to address the issue. How about ILIT copying NewJeans' concept and leakage of the training videos? The court found that these not directly related to the ADOR-NewJeans trust relationship and noted that ADOR protested these issues to HYBE and Belief Lab and pursued legal action against Dispatch for video deletion. ADOR's alleged derogatory statements about NewJeans during the first instance hearing, the court deemed these statements as merely explanations to counter NewJeans' claims and not as a breach of trust. Ultimately, the court concluded that none of NewJeans' stated reasons, individually or collectively, constituted an objective breakdown of the trust relationship required to terminate the contract. All right, and then the next part, the necessity of preservation. So, the court here says what broken trust really means. And the very first sentence, they are defining the word 신뢰, trust. Let me show you. What page? Page 12. Right here. Regarding the breakdown of trust relationship, the dictionary meaning of trust is to firmly believe and rely on. This refers to the expectation and belief in the possibility that another person's future actions will not be hostile or malicious to oneself, and the structure of trust is premised on information uncertainty and imperfect monitoring. And the legal requirement of breakdown of trust relationship is an objective fact of broken state and does not mean one party's, once again, subjective or personal circumstances or thoughts, much less a hope for breakdown or intention or desire to cause breakdown. Okay, so the court defined trust as firmly believing and relying on someone, expecting their future actions won't be harmful. So a broken trust relationship must be an objective fact, not just one party's feelings or wishes. Then ADOR is still actively working for NewJeans, like planning fan meetings, proposing discussions, the court noted. But NewJeans, on the other hand, is refusing to communicate. 채무자들은 채권자와의 소통을 거부하고 있다. Refusing to communicate with ADOR. The court emphasized that NewJeans' success involved many people's efforts at ADOR. Simply wanting a specific producer back or feeling disappointed is not enough to objectively prove trust is broken when ADOR is still trying to fulfill its duties. Here, and behind NewJeans' success were the efforts and dedication of many stakeholders, including ADOR's executives and employees. Adhering to this exclusive contract is NewJeans' natural obligation as contracting parties, and the objective fact of a broken state is not acknowledged merely because NewJeans claim a breakdown of trust relationship for the aforementioned reasons. Okay? So, the court found a strong need for the injunction to protect ADOR's interest. Yeah, wait. Oh, yeah. 소결론, right? So putting everything together, the court decided that NewJeans' reasons did not show an objective breakdown of trust, and therefore NewJeans' argument that they could end the contract on these grounds was rejected. So that's a conclusion on broken trust, stated right here. Now, why the temporary order is needed? That's this part, judgment on the necessity of preservation. So first, balancing the interest of both sides. 이해 득실의 점에 대하여. The court decided the temporary order was necessary because, first of all, if NewJeans worked independently, ADOR would lose all its massive investments in their debut, and NewJeans would unfairly gain all future profits. Also, NewJeans performing independently, like their Hong Kong concert using NJZ, they specifically mentioned AG, that is NJZ in Hong Kong concert. This could make the public think the contract was ended, severely damaging the NewJeans brand image. Furthermore, NewJeans is ADOR's main group, and their activities are crucial to ADOR's survival. If NewJeans left, ADOR could face collapse, harming its employees and many other people involved. True that. NewJeans claimed that they would suffer irreparable harm from inactivity, but the court said this harm was self-imposed because they were refusing to work under a valid contract. I cannot help but feel glad that the court is using these phrases like self-inflicted and self-imposed when it comes to like Min Heejin's and NewJeans' arguments, because they are seeing right through. Where is it? Page 14. E. 직업 수준. As a result, in particular, management. So there's no reason why situation. 이유가 없다. 그냥 불가하고. Okay. 가나다라. NewJeans argued that if this application is granted, irreparable damage will occur due to a long period of inactivity, but this damage arises from NewJeans' refusal to perform this valid exclusive contract and is merely damage caused by NewJeans themselves. So there you go, self-imposed or self-inflicted. for that one. Okay, so here's a summary. If NewJeans engaged in independent activities, ADOR would suffer severe disadvantages by losing its massive investment, and NewJeans would unfairly monopolize future profits. Unauthorized independent activities, like their overseas concert using NJZ, could lead to public misunderstanding that the contract was terminated and severely damage the NewJeans brand image. Given NewJeans is practically ADOR's only group and accounts for almost all of ADOR's sales, their arbitrary departure would create an existential crisis for ADOR and harm numerous stakeholders, including the employees and staff and the executives. The court stated that any irreparable damage to NewJeans from inactivity was due to their own refusal to perform under a valid contract. Boom. All right. Next, regarding infringement of freedom to pursue profession or create art, 직업 수행 내지 예술 창작의 자유침해의 점에 대하여. So, impact on freedom to work as an artist. The court stated that the temporary order does not stop NewJeans from working as artists. It only requires them to work with ADOR's approval, which is their obligation under the contract. Simple as that. And it's not an infringement on their freedom to require them to follow their valid contract until the main lawsuit is resolved. And ADOR is actively planning NewJeans' future activities and has every reason to support their success. So there's little risk of ADOR unfairly stopping their work. There we go. The court ruled that the injunction did not deprive NewJeans of their artistic freedom. The injunction only requires them to engage in activities with ADOR's approval, not prohibiting all activities. In fact, this is what all idol group members are following. Follow the contract. Adhere to the contract. Adhering to the valid contract is their natural obligation. ADOR is preparing new proposals and promises full support, and it is in ADOR's best interest for NewJeans to succeed. 당연한 의무이다, right? I think I wrote this in my thumbnail for the previous video. Yeah, it's your obvious obligation. It's natural obligation. Since NewJeans are parties to this exclusive contract, adhering to this exclusive contract is their natural obligation. So there we go. So, conclusion on necessity. Based on these points, the court found it was absolutely necessary to keep the temporary order in place. This order ensures ADOR remains NewJeans' manager and prevents NewJeans from performing independently until the main trial about the contract's validity is finished. There we go. There was sufficient necessity for the provisional disposition to temporarily affirm ADOR's management status and prohibit NewJeans from independent activities until the main lawsuit on contract validity is decided. So the final decision. 그렇다면 이 사건 가처분 결정을 그대로 인가한 제1심 결정은 정당하므로 채무자들의 이 사건 항고는 이유 없어 이를 모두 기각하기로 한다. So the High Court confirmed that the earlier temporary order was fair and correct. Because of this, all of NewJeans' appeals in this case had been denied. Yep, finally, just all appeals filed by NewJeans members are dismissed as without merit. There we go. I thought that was very well written and reasonable, although I'm pretty sure, I wonder what NewJeans members themselves are thinking right now and how they feel about this. So NewJeans members, I'm curious about NewJeans members, their parents, 세종 lawyers. They probably knew that this was coming, right? Because they're the professionals. They're supposed to. And Min Heejin. Who knows? Feel free to comment with your opinions. I hope this was informative. And when you comment and communicate, let's stay positive, respectful, and classy. I'll keep you guys updated if there are any further updates. All right? Peace and love. Bye-bye.